Every day in the USA, people find themselves in court.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Victoria Lorraine Williams, case number 2024 CR 28. Victoria Lorraine Williams now appears at a court security monitored Zoom location at the Butler County Judicial Center. Ms. Williams, you are late.
Sorry, there was a couple of people in front of me with walkers that he was having to scan and all of that with the metal thingy.
You couldn't have arrived a few minutes early to make sure you got checked in and in place by your scheduled time?
Sorry, Your Honor. I thought 3 minutes was enough. I'm sorry.
Before the court at this time for further hearing in regards to warrant to show cause alleging certain probation violations. Record that this matter was continued over from the date of July the 16th due to Ms. Williams not appearing at the Judicial Center. The allegations before the court are failing to report as directed, failing to pay as directed, failing to obtain a drug and alcohol evaluation within 60 days and completing the recommendations, and failing to submit to random but reasonable urinalysis as directed, as alleged by Ryan Smith, the supervising court services officer, who is present on this meeting with us. What are your client's desires regarding these allegations, Mr. Favre?
Your Honor, in regards to the allegations, Ms. Williams will stipulate and waive her right to an evidentiary hearing.
All right. Ms. Williams, your attorney has made an announcement that you now intend to waive any due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, Joseph Favre, present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
And do you now waive a hearing in this case and stipulate and agree that you committed the violations as the court had summarized earlier?
Yes, Your Honor.
The court finds that the defendant has waived her right to a hearing and stipulates and agrees that she committed the numerous violations that the court had read off earlier. The court does find that these are substantial and material violations of the terms and conditions of this defendant's probation. We'll now turn to a dispositional phase of this hearing. I'll ask for recommendations from various persons, starting with Amber Norris on behalf of the state of Kansas.
Thank you, Your Honor. Defendant has been on probation as of March 11th of this year, being supervised by court services. Your Honor, I did have opportunity, obviously, to read the warrant and then also the request for revocation that Mr. Smith provided. And Your Honor, it seems that he's basically, I think, been having problems from the beginning. The reporting, either rescheduling, being late, seems to be a bit of an issue. And then she was to have an evaluation in a certain period of time, and she basically lied to her court services officer not once but twice about just the scheduling of said evaluation, not even the actual whatever it says she needs, whether be treatment or no treatment. And so we're still basically where we were in March when the court first sentenced her regarding that particular condition. And it also appears that she's not going to be cooperative when it comes to UAs. As Mr. Smith made some requests, and she had multiple excuses why it was that she could not provide a UA at the time that he made the request, which made sense after the not scheduling the appointments or not scheduling the evaluations and lying to Mr. Smith about them. Seemed, rather suspicious. I not sure how successful she's going to be able to be on probation if she can't report in a timely manner. But really, I think probably her biggest issue is it doesn't seem like she can be honest with Mr. Smith or whoever is supervising her and follow their instruction. So that's certainly going to make it hard for her to be successful and complete probation. Her underlying sentence, Your Honor, is 6 months. I don't believe she has any jail time credit. I believe she at least deserves a sanction, but I probably have to agree with Mr. Smith's assessment, at least some of the information that he provided, that based on the violations that he's seeing, that she be revoked and be ordered to serve her underlying sentence if she's not going to be compliant with probation. Not sure where else we can go at this point. And I don't have any further recommendations for the court, and I don't believe the court would need to address, well, since it was pled as a misdemeanor, I don't believe this court needs to address additional attorney's fees.
Very well, Ms. Norris. I want to make sure that the defense has an opportunity to respond to any statements made essentially in support of sanctioning in this case. So I want to address Ryan Smith, the court services officer at this time. I think that you made your position known in the paperwork that you filed with the court, essentially that this may be a case for consideration of an outright revocation, Mr. Smith. But has there been any change in this defendant's performance on probation after you filed this warrant to show cause, which perhaps puts this situation in a different light?
Your Honor, rather than just a short statement of yes or no, I will tell the court that after our hearing on July the 16th, she was ordered to contact me, and she did. And part of that phone call was her asking me to give her a chance to not ask that she serve her underlying sentence, and that she could do the probation. And we kind of made a deal that I may change my recommendations if she would show me that she is going to be successful. I don't have anything at all. I haven't spoken to her since that date, showing that she's scheduled an evaluation, completed an evaluation, made a payment on her case. I don't know if she's clean or sober. So, Your Honor, based on our last conversation and no proof of anything, my position has not changed.
Very well, Mr. Smith. Mr. Favre, your recommendations to the court?
Judge, we are asking the court consider giving Miss Williams a sanction here. Miss Williams has obviously had a rough start to her probation. There's no doubt of that. It's been outlined very well by Mr. Smith. She informs me that she has gotten her drug and alcohol scheduled. She did not give me the specific details of that, but she does tell me that since her conversation with Mr. Smith, she got her drug and alcohol evaluation scheduled. I was under the impression she had given that information to Mr. Smith, although apparently not. She also has informed me that she has letters verifying her employment. And I am again, I was informed that she had turned that into Mr. Smith, so I guess that is maybe not accurate. I do know that Miss Williams does work. She's a home health care worker, in addition to working other odd jobs where she does construction and other rehabilitation type work. We'd ask the court to consider giving her a little bit more time to get this right. It is her first time up on probation violation here, and I think she does have a job where she takes care of an elderly gentleman. It's one of her duties, and he has an appointment on the 31st of July that she has coverage until that time, but she would like to be able to be released by then to take him to his appointment in Kansas City and do the things she needs to do to keep employed. So that would be our request at this time.
Very well. At this time, the court will address the defendant, Victoria Lorraine Williams, and I'll ask her personally, does she have any statements that she wishes to make in mitigation of punishment here, or anything further that she would like to present to the court?
Yes, Your Honor.
You were waving some papers around earlier. Let's start
Yeah.
off with those.
I I did obtain the employment verification letters to give to Ryan. And I spoke with South Central Mental Health. I got my application, my insurance and everything turned in to do my drug and alcohol evaluation with them. She has not responded yet with a date on it, but everything has been filed, my insurance and everything was taken care of. I'm just waiting on a date from her. I was supposed to hear from her this morning. I have not yet, so on that. I do ask, I did get a rough start to my probation. It was a lot going on, and there's no excuse in the world I can make for screwing up. I mean, I did it. I'll be the first to admit it. But it's like I asked Ryan, please allow me another opportunity to prove myself that I can do this, that I will do this. I don't have a choice. I have too much riding and too many people depending on me right now to be screwing up and doing this stupid shit. Pardon my French, Your Honor.
Who is depending on you?
Both my daughters. One just had a second baby. I babysit her. Both my daughter's kids while they work. I reside with Curtis Westbrook. He's got congestive heart failure and he's got amyloidosis, which is a death sentence for him. So it's taking care of him in his home and getting him to doctor's appointments, managing his meds. I mean, literally being there for him for everything. I mean, he has mobility issues. He's got a lot going on, and the life expectancy of somebody with amyloidosis is 4 months to 7 years. He's got it in his liver and his heart, so he's not looking at long. I just don't. I can't turn my back on him, and I don't want to leave him high and dry. So I'd ask the courts to please consider that when making their decision.
Very well, Ms. Williams. When one looks at the sentencing journal entry in this case, I suppose you could construe it to be a sentence for probation. And that's essentially one of the orders that the court made. But Ms. Williams, really what the sentencing order was 6 months in the county jail.
I know.
You are given the opportunity for an alternative to actually serving that 6 months in the county jail by completing probation and its requirements. You were so inspired to be given that opportunity that you basically didn't do anything. While I realize that the charge in this case that led to conviction ultimately was possession of drug paraphernalia with residue, essentially, as the court recalls, the court wanted to take a rehabilitative approach in your case. In other words, make sure that if you had any substance abuse issues, that those got addressed early on in your probation period. Therefore, this court specifically ordered that you had to have your drug and alcohol evaluation completed within 60 days. So you didn't take that seriously at all. You didn't get it scheduled within 60 days. You haven't started with any type of therapy or counseling or educational program because you don't even have your assessment done yet. And yet we're past 4 months from your sentencing date and you still haven't done it. But today you come in and say, well, I've at least scheduled it now. Well, it's a little bit too late, Ms. Williams, because here's the thing. Either you choose to do the probation or you choose to do the jail time. It's not the court's decision here. Not really. It was yours. You had full control over whether you stayed in the community or not. You just said, I'm just going to blow this off and I'll get away with it. I think you were confident that you could just not do anything that you were specifically ordered by this court to do, and yet nothing was going to happen to you.
No, that's not
Wrong.
true.
Wrong. So what did you do, Victoria? If you want me to give you another chance, just tell me what you did within the first 4 months of your probation that should give this court any reason to believe that you could successfully complete.
You want me to be completely honest with you? Nothing. I did report. That's
Did
it.
report?
I did report. That's about I mean, I'm not gonna lie to you. I've been under so much stress and so much hanging over me, and I kind of gave up for a minute. I really did. But I got my job back. I got going back in the good graces with my kids. I get to watch my grandbabies now. Yeah, I made the drug and alcohol evaluation. Yeah, but it's like you said, maybe it is too little, too late. But all I can say is at least I'm trying now. At least I'm putting one foot forward to get it done and get it done correctly.
Why did it take a probation revocation proceeding to make that happen in your own mind? You did not take this court's sentencing orders seriously enough? So now,
I
4 months
did.
later, it's like, lo and behold, I get it now. I could go to jail for this. Then you all of a sudden want to make a commitment that I thought you made at time of sentencing, Victoria.
And
And then you did not
too.
take any part of this case seriously. You didn't take any part of the probation seriously. It was just like, I'm in a rough time right now, so therefore I don't have to do this.
I mean, I didn't say that I didn't have to do it. I did report to him, but it's like I said, I'd given up. I mean, there was just so much hanging on me and over me that I gave up. I really did. But then I got my bounce back, and I'm trying. I'm getting everything legally dealt with, and I'm back. I got my job. I'm going. I can do this. I really can. I
just wish
got
you
it
would have
together
showed this
now.
court and your probation officer that you could.
And that's what I'm asking
Saying
for.
it is one thing, doing it is another.
And that's exactly right. You're that couldn't be any more truer. But that's why I'm asking for a second chance.
Right.
This is my first revocation, so I'm asking for another chance, please.
I don't know how many chances you think you get, because this court is of the opinion that when you were placed on an outright probation at time of sentencing, that was your chance. There is no magic number of times you get to come back and get a minor sanction or a little slap on the wrist and get another chance. This court would have to have some reason to believe that you could be 100% successful on your probation program, and the court has no such confidence. Therefore, the court will enter an order at this time, having found substantial and material violations of just about every important aspect of her probation. Court will enter an order outright revoking the probation of Victoria Lorraine Williams at this time, ordering her into custody to serve any remaining balance of the original 6-month sentence that was imposed in this case. I will inform Ms. Williams that she does have a right to seek misdemeanor parole under Kansas statutory law. The court does order that the sentencing journal entry in this case that stems from today's hearing does reflect the appropriate number of jail time credit days that she's previously earned, if any. Because of the court's incarceration order, no additional fees will be assessed for her legal services in this case. However, anything that was previously owed is still owed, and if it hasn't already been sent to collections, the court declares it to be immediately due and payable and collectible and can be sent to collections for further handling. Does order, the court at this time orders Ms. Williams to the custody of the Butler County Sheriff's Office until she can be taken to the jail to serve the remaining balance of her sentence. Ms. Williams, you wanted to address the court one more time?
Yes, please.
Okay.
For Curtis's health and well-being, is there any way I could please request house arrest? I will do whatever. I swear to you, I can't leave him. He will literally die. I can't do that. I'm begging you. I will do whatever I have to do. I will do whatever. Please don't make me have to leave him. He's here with me today.
Your security officer who's with you, Ms. Williams, is a very fair man. If I would suggest to him that you be allowed to make a phone call to perhaps set up substitute care or to let someone know what your situation is, I think he will accommodate that. Because I think under that situation, you should be allowed to make a call and let someone know what your situation is, which is essentially long-term incarceration.
Please,
okay.
Mr. Ricke, please consider house arrest, please.
I've considered it. I reject the notion. that
He's
your
here with
request is
me.
rejected. Your request is rejected.
No, Mr. Favre, what are you doing? Help me.
Okay.
Mr. Ricke, please.
Normally, I'm addressed as judge or your
I'm
honor.
sorry, Your Honor. I'm sorry. I don't know what to say. I'm just freaking out. Please consider house arrest. Please.
Judge,
I'm
I-
begging you.
All
Judge,
right.
I will.
Victoria, I just wish that
Please.
you would have taken this case as
Yes.
seriously before as you apparently do now.
Please, Your Honor, I'm begging you
wouldn't
for
hear.
a second
All
chance.
right.
Please.
I do want to give defense counsel an opportunity to address the court. I think he wanted that opportunity. Mr.
Judge,
Favre.
I will say Miss Williams, has been very open about her lack of progress in this case, and not everybody is as open about that. I also will confirm that I have seen and met her grandchildren on the hearings and meetings we've had. She has been babysitting them. I know she provides a substantial care role for them. So her incarceration does impact more than just her. And I would ask the court to consider allowing her house arrest or a modification of sentence of some kind. She does have a lot of things in the fire, despite her lack of progress. She does have a lot of irons in the fire in her life.
I do understand your request, Mr. Favre, and I have no doubt that everything you're saying is true.
Please.
But when you have those kind of stakes involving other people in your life, I would think that you would take your probation even more seriously than someone who doesn't have those responsibilities. Victoria only today takes her probation seriously.
No, Your Honor, I swear to you. Please. Please,
I
Your
understand Mr. Favre's request.
Honor. Please.
And your advocacy on your client's behalf, but
Please.
the court
Please.
is not going to change its previous order.
No, please, Ricke, please. Please don't make me do it. Please,
All
you'll die.
Nothing you say is going to change my order at this time.
He's here. Can you talk to him?
I'm ordering Victoria into custody, and she has left the meeting, it would appear. I think the court has already entered all of its orders and rulings. The Williams matter will be in recess at this time, and the meeting may be ended for